years, and I was assigned as the attorney to numerous health professions licensure boards which were not big enough to have their own lawyers. And so I was farmed out and had clients like a law firm has multiple clients. Moving now to private practice, I help clients in a wide variety of healthcare settings and contexts, and I do other work in the family court for child abuse and neglect cases and in continuing education. I hold both bachelor's and master's degrees in philosophy from Emory University in Atlanta, and I earned my law degree from the University of Kentucky College of Law in Lexington, Kentucky. I am well-versed in administrative and professional law, where I was an assistant attorney general and representing multiple boards, as I said, too small to have their own lawyer. I also prosecuted their cases before the board, administrative actions, and sometimes court actions and judicial appeals. I've kind of lost count now, but I've done continuing education for over at least 30 national and state organizations and private companies, including webinars and in-person seminars. I will be in New Orleans in 30 days for a national organization as well. I just lined that up. And my current repertoire of clients for continuing education has been inclusive of the national and state organizations such as the Kentucky Bar Association, the Kentucky Office of the Attorney General, and the National Attorneys General Training and Research Institute. So based upon the content of this program, I want to make sure that we all cover these basic topics. First of all, we're going to talk a little bit about what I hope are the basics and are probably well understood about the requirements for patient records and privacy. Again, just kind of skimming the surface. But if you get to the end of that section and say, yeah, I pretty much knew all that stuff, then I've done my job as well. We'll also talk a little bit about the duties and obligations of the healthcare practitioner, the duties and obligations of the healthcare practitioner with regards to office staff and employees. We'll talk a little bit about the perils of confidentiality breaches in a digital age, staff use of phone calls, texts, and mailings, and how social media violations may occur by healthcare practitioners or their office staff and employees. By the way, I have an entire separate webinar solely on social media that covers not only office staff and employees, but healthcare practitioners as well. And we're just going to touch on a little bit about social media insofar as how it affects the staff of the office, not just the head of the office like a physician or a dentist or something. So let's move on now to the next slide, please. Okay, thank you. Some disclaimers here. I think it's important to go over what our expectations are so that this can be a good and productive use of our time. I do want to go over the goals and the content as to what this does and does not cover. This does provide a broad overview of HIPAA confidentiality issues and staff issues. It does not cover everything about HIPAA or anything about or everything about any specific health profession. If you're a nurse and you want to do a deep dive into HIPAA for nurses or dentists or what have you, this is not going to cover that. It's going to be generic to healthcare professions and staff. It does educate the person attending, all of you people out there attending to ask the right questions in your own state, healthcare facility, and profession about compliance with HIPAA confidentiality and what training, documentation, and procedures must be employed in order to ensure staff compliance. I will acknowledge a colleague of mine, Stuart Showalter from San Diego. He and I developed some of this material, at least insofar as it regards specifically social media, for the Healthcare Financial Management Association, and it was published in their newsletter about a year ago. So moving on now, we're going to talk about the basics of HIPAA requirements for patient records. And oh, by the way, before we get into the deep dive of our hour together, I am trying to watch carefully of our time so that I leave hopefully 10 minutes of questions and answers time at the end. I've been known to run right up to 60 minutes flat like an Olympic athlete on pace. And I am willing to stay around and answer questions at the end of the webinar, or you can contact me privately or through Compliance IQ. So pacing ourselves as we get started here at the starting line. The basics of HIPAA confidentiality for patient records. You know, this is the federal right of privacy. Confidentiality includes more than HIPAA. It includes state law privacy rights that vary from state to state. It includes sometimes business laws or consumer protection laws about how financial transactions are handled, or like you just can't throw out credit card receipts because in some states that's a business law. And so if you're a dental office that's throwing out financial information like that, you can be running afoul of state privacy laws and state consumer protection laws. Also, there's medical confidentiality as found in state licensure laws, especially in mental health, less in physical medicine such as physical therapy. Medical confidentiality applies to healthcare professionals who are licensed as that professional in that jurisdiction. So, for example, in Kentucky, there is an administrative regulation that governs licensed psychologists, not social workers, not marriage and family therapists, not psychiatrists, but licensed psychologists. And it is a 13-section rule. It goes on for maybe a whole page in the law, 13-part rule on mental health confidentiality as applied to psychologists. And let me tell you, it's not the same between psychologists and social workers and psychiatrists and marriage and family therapists. I think there's less of a privacy interest, or at least less, vastly less rather, not from a HIPAA standpoint, but vastly less state laws regarding physical medicine. For example, I list physical therapy there. In my jurisdiction, you have some just broad aspirational things like saying a physical therapist shall maintain the confidentiality of the patient, and those kind of things shall be responsible for maintaining the confidentiality of the records. And there's very much less a do's and don'ts or a cookbook-style how-tos with regard to physical medicine. And just as an example then in physical. Also, there's medical confidentiality found in national and state codes of ethics. Usually, those are most usually non-binding. That is, they don't have the force of law. They are a courtesy or politeness standard. It's aspirational. It's kind of like the rules of belonging to the country club. If the country club says men have to wear a sport coat and tie to Sunday brunch, then those are the rules of the country club, that men have to wear a sport coat and ties to Sunday brunch. But it is not illegal, and you won't have the government interfere with you. Now, running naked down Main Street at the noontime lunch hour will get you arrested for indecent exposure, and that is against the law. It is not against the law to fail to wear a tie and sport coat to the country club on Sunday brunch. So national and state codes of ethics are kind of like the country club rules on brunch. I have nothing against country clubs, and I am, in fact, in favor of delicious Sunday brunches. But by analogy, the national and state codes of ethics are like courtesy rules, and they are usually non-binding. They are binding on you as a member of that profession for that association. If you choose to belong to the American Psychological Association, their APA Code of Ethics binds you as a member of that association, and if you violate that Code of Ethics, you will be kicked out of the APA and drummed out of membership, like the person wearing flip-flops and a bathing suit is escorted out of the Sunday brunch dining room at the country club. So medical confidentiality can be found in national and state codes of ethics. Usually those are non-binding, as I said. So what does it mean to say usually? Well, if those codes of ethics are specifically incorporated by law into a state's rules or regulations or statutes, they are binding. In my jurisdiction, again, the only private code of ethics that is incorporated into law that I've ever researched or found is the American Medical Association and the American Osteopathic Association codes of ethics as applied to licensed physicians. And so there is a huge Ten Commandment style shall and shall nots that apply to physicians. And one of the catch-alls is don't violate the AMA Code of Ethics because that is incorporated by law. That would be a violation of law. Gosh, I seem to have beat that to death, but it's a project of mine to talk about national and state codes of ethics. Again, could be the topic of whole other presentations. What about employment policies and human resources manuals? Well, again, those are not the law, but it sure will get you fired if you're violating your hospital's employment policies. Also, there are state rules of evidence for privileged communications. Privacy is found in privileged communications. We've heard of attorney-client privilege. You hear that a lot in the news, even today at the national level. And you also have doctor-patient and therapist-patient confidentiality as well. Let's move on to the next slide here. The basics of HIPAA privacy should be pretty well known. You know, there was an update significantly for privacy rules, with those updates being effective in April 2003. We all know the original HIPAA law applied to providers who submitted payment requests via electronic means. Pretty much has got to just cover everybody in one way or the other. I don't ever hear any talk about somebody saying, hey, I do everything by paper and I don't have to comply with HIPAA. I'm just not sure that's the case anymore. So we have, of course, the definition of protected health information, or PHI, for a covered entity. It also covers independent contractors who are business associates. We'll have a slide on that later. It does even include law firms who hold medical records as protected health information. You know, the general definition of protected health information is any information held by a covered entity that concerns health status, provision of health care, or payment for health care that can be linked to an individual. It's interpreted rather broadly as to include any part of the individual's medical record or payment history. And you're going to see this a little bit later when we realize how easily it is to link something to an individual, even just talking on the phone. So the basics of HIPAA requirements for patient records, we have the definition of protected health information. That can be found in any form or medium, paper or electronic, that is created or received by a healthcare provider, a health plan, public health authority, employer, life insurance, school or university, or healthcare clearinghouse. Not sure what a healthcare clearinghouse exactly is. It also is anything that relates to the past, present, or future physical or mental health or condition of the individual, the provision of health care to the individual, or the past, present, or future payment for the provision of health care to an individual. Also, you will have individually identifiable health information is health information that identifies the individual or with respect to which could be reasonably identified reasonably used to identify the individual. And again, we will see some topics about that next. Moving on now, please. Next one. Okay. Overview of HIPAA confidentiality with patient consent. Let's start with that. Things that you know that the patient can always consent to. And I would posit to you that for the purposes of all the rest of our discussions today and this presentation, you know, the HIPAA office staff is going to mess up for you everything from your receptionist up to your office manager when they do things without patient consent. No receptionist gossips over the phone but asks, excuse me, can I gossip about you over the phone, about your medical condition? I guess you could consent to that. I don't know. But the implied consent is for insurance filings, billings, and other things. Express consent is for any reason or for no reason the patient wants the information, and that consent can be delegated, such as providing records to the attorney of the patient. Patient may say, I want a copy of my records, and give them a look. The patient may say, I want them for my attorney, and you can give them to her. She wants to have a look. Also, there are exceptions to confidentiality and exceptions to HIPAA, usually found in mental health laws or the treatment of minors in mental health situations. Other things where, like in a contested child custody case, a minor may hold the privilege that can be asserted by a guardian ad litem or the psychologist or mental health therapist directly. And that has more to do with evidence than HIPAA law. You also have law enforcement exceptions to HIPAA. It's a term broadly applied to the government, and that is, in fact, one of my other and primary HIPAA webinars is about law enforcement exceptions. So you have questions that all of this raises. Can you waive your HIPAA privacy rights with a covered entity? Can you consent to gossip and things like that? What about a specific disclosure for media use by the covered entity? If you might appear in an advertisement for the office or on social media, you could consent in limited ways. If it was limited to your name and photograph for purposes of a brochure or publication. Those are all very good questions to ask about how you might be able to consent. So we will move on now to specifically office staff issues. How are office staff different than business associates? We know that HIPAA applies to business associates as well as the individual practitioners and, of course, office staff. What is a business associate? How is that different? Well, a business associate is a person or organization other than a workforce member of the covered entity who performs certain functions on behalf of or provides certain services to a covered entity that involves access to protected health information. Business associates provide services to covered entities that can include billing and claims, the processing thereof, consulting and data analysis, financial legal services, or if a covered entity enlists the help of a business associate, then a written contract or other arrangement, but the two must detail the uses and the disclosures of protected health information and that the business associate may make and require the business associate to safeguard the protected health information. Here's a question that I got recently. A licensed marriage and family therapist that I'd helped with before said, "Oh, Mark, I went to this seminar who said that therapists who have lawyers need a business associate agreement, so send me your business associate agreement." And I responded that, well, your continuing education provider was really only mostly correct, or at least partly correct, because as it turns out, lawyers and CPAs do not have to have a business associate agreement only if they have access to protected health information. So, for example, what did I help this client with? I was reviewing her informed consent forms, her financial statement and policies. She consulted with me on a case about a patient, although the patient was a named party in a lawsuit. They were going through a divorce. It was ex-wife against ex-dad, and the little kiddies were involved. And so I said, I don't think I need a business associate with you, or rather you need one with me. I haven't learned any protected health information. Now, if you're having me defend you in a medical malpractice suit or a state licensure complaint where I am looking at the clinical record and going over the who, what, where, and when with you of that patient's treatment and service history, and obviously have access to their diagnosis, their medical history, and things like that, that is indeed something that you do need a business associate agreement for. But with regard to office staff issues, the things that I talked about, a business associate, let's go back one slide there. Okay, billing and claims, consulting and data, financial services, those kind of things like that, that leads us right into this. Don't office staff do most or all of those things? Well, of course they do. Business associate agreements are with people who are third parties and independent. Staff in these cases are simply the, quote, workforce members of the covered entity. They are your staff, your receptionists, and your persons. Now, for purposes of our HIPAA analysis today, I'm going to assume that there is an employer-employee relationship where the employer sets the conditions of employment and directs the day-to-day work of the employee. I think that's probably the dividing line between your workforce members and persons who are business associates, because if you have some third party comes in a half morning a week to do your billing and insurance claims, you're not directing how they do that. You're hiring them to do it because they know how to do it better than you, and they'll direct themselves on how to do that. You're not really, you may set a convenient schedule like, oh, come in at the end of the week and handle all my claims and insurance filings. But if you're not controlling their day-to-day work activity, then they are business associates who, if they have access to protected health information, need to have a business associates agreement. Otherwise, I'm presuming you've got an employer-employee relationship and that you are directing the work of your staff and your employees. Also, there's a presumption here of employment at will, where you have let me go back to that. presumption here of employment at will, where you can fire your staff at any time for any reason or for no reason, or even a bad reason, unless it's for a discriminatory reason like age, sex, religion, political beliefs, those kinds of things. Some states may protect those, but otherwise you're thinking of the classic age, gender, religion, those kind of things like that. You can't fire them for that reason. Oh, you can just fire them. You just can't fire them for that reason. So the presumption of an employment at will. And by the way, quick side comment on employment at will. Everybody talks about how employees and workers can be fired any time for any reason or for no reason or for a bad reason, as long as it's not a discriminatory reason, that they never say that it works both ways. It says that, yeah, your boss can come in and say, I don't need your services anymore, you're out of a job, pack your things and go. But also it works the other way, because as an employee, you can fire the boss. You can come in and say, I don't want to work here anymore, I'm packing my things and leaving, I'm working down the street for somebody else. So just when you talk about things like employment at will, just remember that, quite frankly, it works both ways. Is there anything advantage of that? I think so, just to keep in mind that you have the right to quit as well. With regard to office policies and employment manuals, I would assume that every healthcare facility or office, if you are a small office, you may have an office policy manual on employees, or at least a job description. You know, everybody ought to have a one-page employment document, a one-page employment file at a minimum that has your start date, your end date, what your salary is, how many hours you're expected to work, your vacation benefits, and you can slap something in there about HIPAA and confidentiality as well. You've got to include that if you have employees and you keep an employment or HR file on them. Employment manuals would be something more complicated, like a facility would have, that would have a different job descriptions, department from department. So there's presumption of employment at will. There's a presumption that you have at least some kind of employment record of the individual, office policies and employment manuals, and that you do HIPAA training as required, and that is noted as completed. Moving on now. What about training? When you hire someone, if you're a medical office, if you're a dental office, if you're a nurse getting hired in, if you're working at a hospital, what about training? What are the training requirements for HIPAA? Well, HIPAA applies to many different types of covered entities, and the training of office staff is mandatory. See these codes of federal regulations that talk about training. However, in order to be as flexible as possible, dare I say that these rules are even vague, is that it says training must be provided as necessary and appropriate for members of the workforce to carry out their functions, and that covered entities must implement a security awareness and training program for all members of the workforce. And there is no specific HIPAA training requirements for staff. You pretty much treat them all the same, everything from the janitor over to the receptionist and the bookkeeper and such like that. The training must be necessary and appropriate for members of the workforce to carry out their functions. And I would say that a lot of the things that you would say to anyone would be things you would say to all. So what about objectives of training as applied to the staff of a covered entity? You're going to have training. You're going to have training as necessary and appropriate, and you're going to train pretty much all the people in the same way, or at least as you'll see later, we are going to start out that way. Just a moment, let me get a glass of water. Well, so what objectives of the training should be applied? Well, this depends on security awareness and the training program as applied to the functions or role of each individual staff, employee, manager, volunteer, trainee, or contractor who may have contact with protected health information. I would still recommend starting with, you ought to have enough of the basics that would apply to everybody, no matter what kind of staffer they are, because there are so many universal things about not looking at computer screens, not picking up patient records that aren't your patient records, those kind of things like that. HIPAA training is required for new members of the workforce within a reasonable period of time. There is the magic key, where the law does not say a specific time. The law always implies a reasonable time, and you are supposed to know what reasonable is in your workforce or your profession. Here, the law specifically says, quote, within a reasonable period of time after the person joins the workforce, and also when functions are affected by a material change in policies or procedures. So if the typo there, that should be policies or procedures. If there is a material change in who does what, HIPAA training may be necessary, as well as new and updates and things like that. That also has to be done within a reasonable time. So is this even same day? Can reasonable be same day as a hire? I think it can be. I think you ought to have, I think if you're running a dental office or a medical office or a mental health office, you ought to have something that you tell people, something that you tell new hires on day one. Probably wouldn't take more than 10 minutes to tell them kind of the basics of what you expect for them. And in fact, I add this into the content because I think it's something you should cover this in an hour-long job interview to discuss confidentiality. You probably need to bring that kind of thing up when you're interviewing for a receptionist. You can say, this is a dental office, and we have records here, and people are coming in to get their dentures adjusted and things like that. Are you sure you can work in an environment where you're not allowed to gossip, where you're not allowed to tell other people what's going on outside of the office on anything other than a need-to-know basis? So I think I would say cover this in an hour-long job interview and discuss confidentiality when you're looking at a new hire. HIPAA training is also required periodically. Is it annually? Well, that's going to be the recommendation later. HIPAA training should be provided whenever there is a change in working practices or technology, or whenever new rules or guidelines are issued by the Department of Health and Human Services. That is the agency that's in charge of all things HIPAA. So what about an overview of staff issues and content? What about areas to cover in a HIPAA training course? These are the bare things that you ought to be able to cover. And by the way, probably most of these things you could at least cover what they need to know in 10 minutes of a new hire. And I would say that within a reasonable time for a lot of people coming into a medical practice or a dental office would be day one. Again, if you've covered it in your interview, you've already started that process. But the things that you need to say are about what is HIPAA, what is the federal right of privacy, what is the HIPAA privacy rule and the HIPAA security rule. Why is HIPAA important? Why do we have this federal law about medical records? What about kinds of disclosures of protected health information? What can you say and to whom? What about safeguarding protected health information when used electronically? Faxing records, sending an email, saving an electronic medical record, an EMR. You should go over some of the HIPAA definitions. We've already talked about what protected health information is. Breach notifications, if you realize someone has taken the medical file or your flash drive has gone missing or what have you, you should tell staff what to do and how to bring that to someone's attention. Also, potential violations. You need to tell office staff the kinds of possibilities and sanctions that will occur. You also need to discuss patient rights, what they have to do, what they have a right to know or have a right to limit. For example, calling you at home for your appointment reminder, never calling you at work, or vice versa. You should also let them know a little bit about business associate agreements that you will be having. You may be having contractors, or your CPA may be coming in, or your computer tech person, and they are going to be bound as a business associate by the same thing that you would be bound as well. So employee sanctions is something that specifically is a bit beyond the scope. Let's go back, please. Specifically beyond the scope of what I'm going to cover, but you need to let people know that there are those things. So where can I get a HIPAA training course? Well, I don't do them, thank goodness. I don't do HIPAA. HIPAA is not something that I deal with, every day in my practice, but I am aware of HIPAA confidentiality and I'm not the right person to do training on HIPAA to healthcare professionals directly like that, you can go to the Federal Department of Health and Human Services, which provides free training materials on HIPAA training and resources. This includes various elements of the privacy and the security rules and includes guidance materials. And you can look for that under this website of the Department of Health and Human Services, a federal agency. So we're at least halfway through our presentation, and we are going to finish and have time for Q&A. So train your team on HIPAA. You need to have everybody on the same page, whether they be the janitor, the receptionist, or anywhere left or right in between. At a minimum, train your employees every year, and also when new HIPAA rules and procedures are announced, have your staff sign and acknowledge their awareness of these HIPAA policies and procedures, and document those training dates and employee names as proof your employees have been trained, including newly hired employees and staff. And that you could do it like this. For documentation of newly trained and hired staff, you could have them put that. You could have some of that HIPAA and confidentiality referenced in their job description. Like think of a receptionist's job description. The receptionist shall do these things and shall not gossip about patients, shall not reveal information other than accord with someone's written permission, et cetera, et cetera. But otherwise, train your employees every year, have a brief HIPAA update as part of your staff meeting, have them sign and acknowledge their awareness of the HIPAA policies and procedures, as I said, and document training dates and employee names as proof that your employees have been trained. And you will be able to keep that documentation. It may help you later if there's a problem. So how do you prevent HIPAA violations by office staff? You've hired them, you've trained them, they're not business associates, they're office staff, they're members of the workforce, you've talked to them about confidentiality. What can you do to prevent specific things that are violations, that can lead to violations, and maybe that are not violations by themselves? Well, never disclose office passwords or your computer password, or share login information, computer credentials, and such with other staff. If there's an electronic medical record or scheduling, everybody in the office who does that work needs to have access to the same thing, but in their own name. If you forget your password or you can't come up with a new one when it's time to come up with a new one so you can get into the scheduling system, don't let someone borrow the password and credentials login from somebody else, because then they are logging in as you and they may have access to things that you are not allowed to have access to. Give every staff a unique computer login to access only what documentation is needed for staff. So, for example, a receptionist may never need the medical record, only the electronic scheduling and calendar program where at least maybe their name, email address, and telephone number is revealed. But if they're coming to the doctor's office and they've got a name, you can't say that name. But otherwise, every staff should have a unique computer login to access only what documentation is needed for the staff to carry out their job duties. Never leave a computer device or document unattended. Walking away from a laptop where you're entering data into the patient from the patient's visit, leaving paper documents, X-rays, or laboratory results out on the counter where patients are walking by is a no-no as well. This is something I learned from government practice in the law. Use mandatory screensavers. I know it's a hassle, but I've seen law offices and other government agencies that say we have a 60-second lock. If you're not on your computer actively typing away, and 60 seconds goes by, we have a lock screen that comes up. Now, maybe there's a quickie way to get out of that. We're talking about things now like biometric screening. If I access my iPhone, I just put my little thumbprint on the sensor, and it knows that it's me, and I look up my information that I need on that. But for desktop computers, for laptop computers that might be used in the patient room or examination room, you probably need to have something as simple as a 1-minute screen lock, and people will get very, very good entering in their, 4-digit code because they turn away to do something or administer an injection, and then the computer screen freezes up. That's so that you just don't walk away from it entirely, coming back in an hour with your laptop open on a table that is visible by people in the lobby or things like that. Have a rule for paper records to prevent viewing by unauthorized individuals picked up by other healthcare workers or seen by other patients. You should have rules about how records are maintained, physically maintained, who's in charge of maintaining them. You may have a busy medical office or dental office that's seeing, a dozen, 2 dozen, 3 dozen patients a day. And those records should be either immediately put back into a secure location or they should be put in a pile of secured records that some staffers in charge of refiling on the shelf in the right order at the end of the day. Don't just let them stack out on the end of a conference table or in an operatory because that leaves those paper records vulnerable to be seen by other patients. Before we get on to the disposing of paper records, I will tell you that, again, been in a lot of medical offices in my life and was at a medical office, nice lobby, very nice accommodations, very comfortable, very warm medical office, and there was a receptionist room that was a little bit smaller than the lobby, but not much, and all of the records for all of the patients in that practice were lined up on 1 or 2 of the walls, all the way from A to Z, from the floor to the ceiling. And those records were behind the counter, behind the receptionist desks, and were physically walled off from the lobby. That's not what I wanted to mention that was so interesting that kind of hit me later about this situation, and that is that when I went up to the desk, they had sliding glass doors on the countertop, and in order to speak to someone, I had to rap on the door, or I got their attention, or they saw me as soon as I walked in, and they opened the glass door. Can I help you? And I said, yes, I'm here for my 2 o'clock appointment, blah, blah, blah. And then when they got done, transacting, confirming my name, my address, my health insurance status and information, they said, well, please have a seat. We'll be right with you. And they closed that window. And I thought, what are we in, a bank or something? Is this like passport control where we're going into another country and you're speaking to someone behind glass? And I realized they're doing it for confidentiality because you had 2 staffers there, all the medical records, updating billing, talking back and forth about patients and diagnoses and insurance billings and payments and stuff, and they were doing that behind a glass partition. And I thought, that's pretty appropriate, and I like it, after all, that they are not just doing that for other reasons, but they had, in fact, a clinical reason for doing so. Also, with regard to paper records and financial receipts, those all should be shredded. Remember, financial receipts are things that come up in other laws, business laws and consumer protection laws, and the disposing of paper records of any kind should be done by shredding. Basically, my standard, like in my law office, for all of my legal records and such, is that anything with a name on it has to be shredded. Even if it's a public case or a public pleading or document, I might have been drafting a 3-page legal document. When I get done drafting it, I file it at the courthouse. It's a public record. It's a legal document. But by golly, I throw that away because I don't want someone getting that information from my office trash. So how do you prevent other kinds of HIPAA violations? Don't text patient information to anyone. Been reading a lot lately about how unsecure texting is. I'm not very good with texting. I can type really wicked fast with an ergonomic keyboard that I have at work and at home, And email has a little bit better information on it. When you're sending an email, it has a header, things like that. I am not very good at texting. I've meant to text my wife, and instead I hit the last text that my wife was included in, and it went to my wife and 2 daughters. So everybody knew that I was coming home a little bit late for Tuesday dinner. I'm not very good with texting, and I think there's a reason why it's recommended don't text patient information to anyone. It's not appropriate. Now, I have seen exceptions to that where you have a therapist who gives an individual patient their business or private cell phone number and says, if you have a problem or you have an emergency, here's how you can reach me after hours, and texting might be possible or allowed, if nothing else, solely for the purposes of scheduling an appointment or initiating telephone contact in a true emergency. But I thought, that's a pretty darn good rule. Just don't text anybody anything. Never access patient records out of curiosity for yourself or for another person. If you're a staffer, I used a lot of examples in Kentucky about kind of like life in a small town, so to speak, that there will be people who know that individual, and you should never access patient records out of curiosity for yourself or somebody else. An example of that is talking about not having office policies or procedures. A dentist, and there was a senior dentist and his son, the junior dentist, were in a dental practice, and they had lots of young and bubbly dental hygienists working with them, females in this particular case, for example. And the dental patient called after appointment and said, I really liked that office staffer, the other lady who was in the office and working on my teeth. I would be interested in going out with her. Could you give me her name and number? And caught the office manager a little off guard, mixing business, dental, and pleasure. And that's probably not a HIPAA violation to go that way, but probably not a good idea. You need to have an office policy about sharing that information or office and patient relationships. But that's not a HIPAA violation. But what about office staff inquiring about a dental patient? Oh, you have a hygienist, and she sees someone that she thinks is really cute and attractive who's getting their teeth cleaned, and she says, I'm new here. Who is that person getting their teeth cleaned? I'd like to look up and get their information. Maybe I'll call them or text them and see if they want to go to dinner and a movie. That is clearly a HIPAA violation if you are accessing patient records and patient information for your own purposes and not a healthcare purpose. So you need to stamp that out, and that's a HIPAA violation, maybe an office policy violation, a office romance prohibition violation. Those are just things that kind of can work both ways. Healthcare employees should be only permitted to access patient records if they are in fact required to do so for purposes of treatment, payment, or for healthcare operations. For treatment purposes, staff should be only permitted to view the records of their own patients. So you have, again, just for example, you have dental hygienists in a dental office. They should only have access, at least at that moment, at that day, for individual patients that are their own patients assigned for the day. Do not take medical records with you when you change job or take copies with you. I have another very successful and well-received webinar that I've done many times now about medical records and medical record keeping and confidentiality in records. And you may have situations where, say, a dentist leaving a practice wants to take a copy of those records with them, and that's the topic for another day. But when you change jobs, don't take medical records or let those medical records leave the premises. I'm not saying that you can't take medical records home. I've seen psychologists and physical therapists take medical records home to work on, and that increases the HIPAA confidentiality possible breaches by staff, but it's not illegal. It's just that when your car is stolen and you had a box of records in the back seat, that you are updating, you are going to be in big trouble apart from the fact that your car got stolen. Likewise, think about something like your briefcase is in the trunk and you get rear-ended and the records go flying or something like that, can be damaged or destroyed. So don't take medical records with you when you change a job or take copies with you. And although it's not a HIPAA violation to take original records off-site, the risks of a breach are very, very much increased. Do not share protected health information on social media, including and especially photos. We're going to get to that section in a minute. Many healthcare facilities have developed rules covering the use of social media by their staff. Remember, protected health information includes any health information, but also photographs and videos. It does not matter if the photograph does not include the patient's name, because patients can be easily identified. It would be a violation of HIPAA if you took a selfie with a patient who said, "Patient doing great today, can't wait to go home and is recovering." You post that on Facebook and someone looks and says, "Oh, I know who that is. They're my Facebook friend too. They posted the same thing on their page." Selfies taken at work and posted to social media accounts violate HIPAA if the patients are included in the photograph if prior consent has not been obtained in writing. You can obtain consent if you want a photograph of a patient to be displayed in your office brochure or something like that. You're talking about one profession in particular. For example, the National Council of State Boards of Nursing has published a useful guide for nurses on the use of social media that is available from that organization. That is not a nurses association that is a private association. This is a nonprofit entity that owns and develops the nursing exam and is comprised of all the 50 state agencies and U.S. jurisdictions which regulate the practice of nursing. I have the pleasure to know some of the good people there, and I've done continuing education for them specifically in the past. There are high-profile cases of nurses and other healthcare professionals who take photographs or videos of patients and upload them to social media. There's just significant financial penalties for the covered entity where that happens. Nurses lose their job over that. They can have their license disciplined, and they could be subject to lawsuits for HIPAA violations. So let's delve into, let's take about 3 to 5 minutes and talk about social media, things that your office staff can get you in trouble for. We know about social media. Everyone from 5-year-olds up to the president use Facebook, LinkedIn, Twitter, YouTube, Instagram, blog sites, and social media sites that list healthcare professionals. You can go to websites like rateyourphysician.com. Professional websites and blogs also allow space for commentary from the public, sometimes such as a hospital's website. There are physician rating and other healthcare practitioner rating websites, and people use that for good and for bad. So we're going to talk just a little bit about social media. Healthcare professionals post information and pictures about their personal lives, their families, and their work. Those are like the top 3 things that people try to get away with on social media. You have things that are unique to healthcare as opposed to the general public because confidentiality is an issue for all healthcare practitioners. Social media is a valuable tool for patient education, communications, and marketing of healthcare services. Social media is the source of many common privacy breaches. Usually all are well-intentioned or innocent actions, and state licensure boards take an interest in patient confidentiality as well, especially in mental health. This is a very quick story, not about mental health or health care, but what reasonably identified means. There was an Outback Steakhouse in Florida, Outback Steakhouse waitress in Florida, who complained about not getting a tip on a $735 takeout order that was going to a church. We take the order over the phone, we put the order together, we take payment, take it to the car. It works. It's a lot of work just like it is serving. This waitress made just $18 in tips one day because she spent the whole time making a church order of 25 steaks, 25 chickens, and 25 potatoes. She took to Facebook to complain that the church had stiffed her on the tip, although she didn't identify where she worked. She named the church by name but didn't say where she worked. but everybody knew where she worked. All of her friends on Facebook already knew that, and it came to someone's attention. They contacted the church, and the church contacted the Outback Steakhouse, who turned around and promptly fired the employee because the employee had violated a company policy prohibiting employees from talking about customers online. By the way, I assume that is a blanket participation prohibition. You can't say good things or bad things, just don't talk about your customers online and social media. The church had said that they contacted the restaurant after hearing the complaint from this third-party friend to see about getting a tip for her, and they never intended for her to be fired. They said their policy is to tip on carryovers. There was a new volunteer that wasn't aware of that. Lessons learned, you'd be surprised how reasonably identifiable things are in a small town or even a medium-sized town. And violation of employer's policy in a small town like that will get you fired. You can run into foul of HIPAA on social media by any of these things, such as, for example, describing patients vaguely but enough detail that their identity can be determined based on facts and circumstances, posting videos or photographs that include patient faces, hospital room numbers, portions of medical records. Recent news events have revealed those things, and we will get to that on the next slide. Sharing information by email or on social media with coworkers who are not involved in the patient care, or commenting on others' posts using protected health information or one's healthcare-related position as the basis for the comment. I had a physical therapy board case where the physical therapist was treating a little kid, helping him learn how to walk again and how to eat again because he had had a brain tumor. And the family had posted a bunch of stuff on a website that was password protected and by invitation only to family and friends and neighbors who wanted to know and wanted to be informed. Well, the physical therapist steps in it by saying, "Little Johnny, my patient at the clinic, is in bad shape. His brain tumor has come back. Please say a prayer for little Johnny." And little Johnny's parents didn't complain, but somebody saw that and either fired the physical therapist or turned them into the state board because clearly that was a HIPAA violation, and the question was, did that violate confidentiality under the licensure laws for physical therapists? Saying my little Johnny patient is unwell, his brain tumor has come back. So describing patients vaguely, like in a small town, you'd be surprised with. Posting videos that include patient faces, those kind of things we've mentioned. Here's a great news article about social media. Dental students at Yale University took selfies with severed heads. There was a social media breach where people were taking selfies in an operatory while they were doing research, craniofacial research, and the pictures showed people wearing surgical masks. Some people were looking at the camera, others were continuing to work, and there were two severed heads on the tables face up. This was an interesting media story because when it first came out about this happening at Yale University, the media story mentioned, we're not going to publish the offending photo because it's an offending photo. And later it was accessible and came out with people's faces blurred out. And the public did have access eventually to the photo of the students and interns doing medical research on craniofacial for severed heads. The violation in that case of social media was a harm to the university and a harm to the public. There are also similar ethical rules like for schools of embalming and funeral directing, which have strict policies and strict student codes of conduct with regard to treatment of dead human bodies. Because if you know, grandma donates her body to science and some embalming student posts a photo with grandma on social media, people are really not going to want grandpa to donate his body when he goes too. Here there were officials at Yale and the University of Connecticut that were quoted on how they were going to take steps to make sure that this didn't happen again. There was clear signage forbidding photography at the entrance to the laboratory where this happened, but you see people just aren't putting two and two together. They decide to take a selfie in the room, and, you know, there was a sign on the door that said no photography. Well, a selfie is photography, and why someone, I think it's just indicative of somebody who says, hey, wow, I'm doing something really cool today in my graduate and medical education. I'm going to take a selfie and post it on Facebook. Just as like you would say, hey, wow, cool, look at my really great bacon and eggs I had today for breakfast. And that's how people, and I'm going to share it with the world, my bacon and eggs. And I think that's how sometimes people think they deserve to let the world know what they had for breakfast. Great line in the social media article about how social media screwed up in this situation. It was not clear how the heads were obtained, according to the news article. Oh, my gosh. I hope it was clear how the heads were obtained, that they were donated by people interested in science and not like maybe taken off the bodies of people who were still using them. Was that a possibility? Not clear how the heads were obtained. Maybe it was the latter. One day at work, a medical technician learned of an automobile crash. The medical technician worked in the ER and posted it with a sign, working today in the ER, should have worn her seatbelt. This was, again, a relatively small town where people knew each other. The medical technician's comment went viral on social media, and the medical tech was terminated from her job. The medical technician was probably just trying to remind people that seatbelts save lives, but the comment was apparently seen by some as being callous or uncaring. People who work in healthcare need to remember that they are in a special position of trust, and their posts can be easily misinterpreted. Once posted, the comments live forever in cyberspace and can't be retracted. I had a psychologist say that he would tell his adolescent clients that, are you sure you're going to get that skull and dragon tattoo on your chest the day you turn 18? That will live forever and can never be erased. And he says, I don't say that anymore about tattoos as being the most permanent thing you can ever do in your life. Posting something on the Internet. If you're drunk at a high school party and somebody posts that on the Internet, good luck going to law school, et cetera, et cetera. So we're going to end up with just, we're getting very close now to the end, and I want to give other examples of an employer's social media policy which will help staff comply. That they should include prohibitions on posting a photograph or video recording, mentioning a patient, diagnostic image recording, medical record number or a date. I had a story about an expert witness in a medical malpractice case who was able to link a slightly redacted radiographic image with the radiographic image in her $1 million case. Prohibitions on describing patient encounters with enough specificity that the patient or someone who knows the patient would know who they were being referred to. Also responding to posts or public messages from a patient with additional details about their health. So do not post pictures of other patient information without their express consent. The fact that the patient or the family member has already posted something does not constitute valid consent. Just because they say it doesn't mean you can say it. If the family posted on a website, little Johnny's brain tumor is coming back, please say a prayer for him and our family, doesn't mean you can say that. No gossip about patients, even if you try to anonymize a patient's identity. People who know the situation will figure that out. Don't post something online if you would not talk about it in the hospital, cafe, or elevator. Don't forget that everything on social media is basically public and can last forever. Don't use your work email address for personal media, social media activity. And don't forget that on social media accounts you are speaking for yourself and not the organization. Again, the tech who said hard day in the ER, that patient, she should have worn her seatbelt. I can tell you an anecdote. About a dozen years ago, I was in a university hospital's elevator, and they had a little plaque on the wall, dear students and residents and doctors, please refrain from breaching patient confidentiality in your conversations in the elevator. And I was impressed with that. Was going down at lunchtime to sit at the hospital cafeteria and have a sandwich and didn't know anybody. I was there by myself visiting someone and wasn't a doctor, student, or nurse or intern. And so I wandered over to the edge of the cafeteria, which was still filling up at the time, and sat down by myself at a table that had just been made empty when 3 people got up and left. They left the 12-page surgical schedule of the 38 patients that were being treated that day and who had scheduled surgeries. I looked through them. Two people were having breast augmentation, of all things. And so I went right from the elevator, where I was impressed with the sign that said, "Please respect patient confidentiality," to getting my sandwich, sitting down at a table, and there was the entire 12-page, 38-patient surgical schedule that was left by someone on the table. With regard to social media and your staff, you should have an interdisciplinary team review your employment policy or office policy. If you're working in a facility, include all of these people. Do not apply the policies, or rather do apply the policies to the entire workforce, not just healthcare practitioners, and that would be true of a lot of things we could say about staff. Do recognize that in addition to HIPAA standards, the policies must address state laws, other mandatory rules, and sometimes applicable codes of ethics. Do have a single individual named by title responsible for overseeing social media. I think social media is just one of the biggest violations that could happen because of the widespread scope and severity. It's more limited if you have a stray medical record that's left on the counter in between the reception area and the lobby waiting room. But the confidentiality concept should be firmly ingrained into workers and staff in healthcare. You can, again, I refer you back to the Department of Health and Human Services Office for Civil Rights, which has issued guidance on HIPAA and social media. You can even review their compliance checklist for social media on their website. So we've run just a few minutes over today. I think we have one question that's come in, but I want to say that this has been time well spent today. We've covered the basics of HIPAA requirements for patient records and privacy, duties and obligations of the healthcare practitioner with regards to office staff and employees, to have initial training, to have annual or regular training, to have training when things are updated or new come out, and that all of that be done, quote, within a reasonable time. And I think you deserve to bring this up in a job interview and at least have it the first 10 minutes of whatever orientation on day one in a dental or medical office. We've discussed the perils of confidentiality breaches in a digital age. We've discussed phone calls, texts, and mailings, and how social media violations may occur by healthcare practitioners and their office staff or employees. It is now time for questions. Before we move on to questions,